Welcome to Kevin's Corner. I apologize for starting late. I had a morning appointment that ran longer than anticipated, so I just got free and was hoping to jump right into everything today. Excuse me. And for that reason, I wanted to talk about a topic that I've been thinking about doing for a long time. And I actually normally plot these about a month in advance, and I didn't think about this before picking this one, but Mary Galligan from our office did a blog earlier this week, which you can find on our website, galliganmanning.com. It was about updating old trusts for tax reasons, which is similar to what I wanted to talk about, but I wanted to talk about a little bit about why and then how you actually do that. So I think I was just going to jump into that as a topic. And so to sort of set the stage for this, here's where people usually come up with this. A lot of times, especially say 15, 20 years ago, people did trust planning, estate planning, with the estate tax in mind. So most people have heard of it at this point, the estate and gift tax. About 20 years ago or so, it was based upon an exemption amount, about how much money before it applied, of $600,000. And over time, that exemption has changed tremendously. And a lot of times, therefore, because that estate tax applied so quickly, and the actual tax was usually it was different at different times and different percentages, but roughly half of what you had over that amount was tax. So it was like a 50% tax, roughly speaking. So it was a big tax, and you were always trying to avoid it. The loss there, the exchange was, if you were planning for estate taxes, you were accepting or not planning for capital gains tax, and that's usually the tax generally on the sale or the profit of a sale. Okay, so usually if you were planning for estate tax, the scarier one, you were going to take the hit in capital gains, but it was less, so it was acceptable. And where people did all that planning, it was great planning at the time, but now here we are 20 years later, and things have changed. The estate tax exemption went from, again, 600,000 to about 11.4 now per individual. It's by far the highest it ever has been. That law is supposed to sunset in 2025 and then fall back down to probably 5.5 million, but it's still far higher than it ever had been. And there was also other techniques during that time that came into play that made it easier for a surviving spouse to use the exemption that their first spouse didn't use. So if the first spouse used $3 million of their exemption under the current numbers, they'd still have about $8 million to go. And then depending on the elections, the surviving spouse would get to use that extra 8. So in that situation, you seldom have estate tax actually applied to people. Okay. So the issue comes up for now is where people back then were planning for estate tax. A lot of people either didn't update their estate plans and don't need to plan for that anymore, or they had an estate like the first spouse to pass away who used that kind of planning. So they have good estate tax planning. They're not even close to estate taxable anymore. And then they got that trade-off of now they're exposed to capital gains. And I won't go through all the mechanics of that unless you really want to know. So the question becomes, what do we do about this? If you're not worried about estate tax based upon those numbers that I just said, but you know your estate plan has some language in it like bypass trust, family trust, if you maybe used a standalone insurance trust, gifting trust, something like that, chances are that was done for estate tax planning and may or may not be useful to you anymore. Okay? And so if you've already done that, then there's maybe, I'll say 5 ways or so that you can update it now. Right? So first, the easiest one is if there's no one's passed away yet, just update your estate plan. It's very likely that that's true for many, many people. You just simply don't need the planning you did maybe even 10 or 15 years ago, and you just don't need that kind of bypass trust planning focused on estate tax. You'd rather have everything be in estates, and then you get a better capital gains type of treatment. So it could be just that simple. It's have an estate plan reviewed, make sure it still fits. The second one is more if there's already a trust established that's being used, like if someone's already passed away and set up a family trust or a bypass trust. And that is that you can take that irrevocable trust that no one's there to revoke it, you can still change it in different ways. And depending on the terms of the trust, there's lots of different ways you can do it. So one I get to do a visual for, which is great. It's called decanting. And if you know what a decanter is, it's like a vessel that holds wine, for example. There's a concept in trust where you can take one vessel, one decanter, excuse me, and then pour it into a new one you create. So like this for my visual, right? You already have the one trust that doesn't do what you need anymore. It's planned for estate tax, not for capital gains. Depending on its terms, you may be able to take its contents, the stuff it's holding, and actually pour it over into a new trust that you created with terms that fit your current situation. Okay, so that, gotta love the visuals, right? That's decanting. That may or may not be workable again in terms of trust, but is a good place to start. Most trusts now at least provide for that to be possible. The third option, especially if it's already an irrevocable trust, the person who created it can't take it back, you may be able to go to court and ask for permission to change its terms. Now, you can't do that for all bases, but if estate tax or tax planning was a goal of the first trust, a judge might be able to say, okay, if tax planning was the purpose, it's now obsolete based on the way it was done, so perhaps it's allowed to be updated to the current taxes you're trying to plan for. So that is a legitimate basis potentially to come forward and say, hey, we need to do different kinds of planning. Another thing might be simply to take that trust, and we did this for a client recently, this one's a little bit more complicated, but to change the beneficiaries of the trust, if that's an option for you, in a different way to get a different tax consequence. And I'm only going to say that that might be doable. The details of that are highly complicated, so there's no point in going through it right now, but it might just be that simple. Change the beneficiaries to a different arrangement to get a better tax consequence. That certainly does happen. A fifth option might be that you actually can rescind the trust. Now, this is more for trusts like life insurance trusts, for example, that were created during the lifetime. You might not want to do this with the life insurance trust, but if the creator is still around and the beneficiaries all agree and the trustees all agree, again, depending on the terms, you might be able to just break the trust altogether and make it as though it never happened, just totally undo the transaction. Sometimes that's a good option so that you can take the assets back out and then replan for whatever issue that you're trying to plan for in the future. And then finally, this one's probably less relevant, but it's more about administration ease than it is about tax planning, is a lot of trusts have provisions where they can be severed. You know, you have one trust being administered for 3 different beneficiaries, maybe you can break it into 3 different trusts, okay? Or conversely, to merge. Let's say you have 3 different trusts, all for the same beneficiary with similar terms. It might make sense to combine those, or combine them in a way that'll get a better result for you. So there's a universe of options. All trusts have some limiting or permissive language in them, so they have to be reviewed. But there's usually an option to optimize things. So the point is, one, if you have an older estate plan, especially with those kinds of plans in place, bypass, family trust, anything like that, one, it's probably worth just reviewing and having updated, okay? If that doesn't work, if you're stuck with a trust, 2, you might be able to decant it, pour it over into a new trust. 3, you might be able to get it modified to fix or update the terms separate apart from decanting. You might just want to change the beneficiaries, that's 4. 5, you might be able to rescind it to actually undo it and take it back. And then 6, break it up into chunks, either to sever it or to merge it together to make it easier to administer. So I think the takeaway point is, if you did that style of planning, you probably need to redo it. And even if you think there's nothing you can do, it was done right the first time, but it can be perfected now. And just because you think of it as irrevocable, that doesn't mean you can't change it or update it in a way that makes sense within the terms of the document in the law. So if you have any questions about that, or you want old trusts reviewed, that's certainly understandable. We're happy to do that. Please get in contact with us. You can get us through CalliganManning.com or through Facebook, and then you can have a consultation and we can go through the old document and give you an idea of what your options are going forward. Okay? So thank you all very much, and I look forward to starting on time next week.